So without further ado, I'm going to give the floor to Joe Finnerty, who is, I have it in my notes somewhere, I have a trainee solicitor at Digby Brown in Glasgow, Scotland, who is also about to start his PhD at the Hertie School of Governance on Article 18, and who is going to talk to us now about conspiracies and the convention. How does an applicant prove a state's ulterior motive under Article 18 ECHR? Over to you, Joseph.
Thank you very much for the floor. I will quickly share my screen. There we go. So the quick disclaimer that this is given in a personal capacity and doesn't represent the views of my employer, not that they do much human rights in practice. I don't want to step on Anne's toes here with her.
Joe, I don't know if you do that on purpose, but at the moment we see the next slide as well as the present slide. So I don't know if you.
I think both is fine. I think.
Okay, fine, no worries.
I'll leave it as is. But anyway, I don't want to step on Anne's toes here with her concluding remarks, but something that's emerging for me and something which I found in my preparation for this paper is that we are all trying to build these structures or evidentiary frameworks based in our particular fields. And I think it's safe to say that we're all trying to build these structures on marshland with the evidentiary framework as it is at the base level of the ECHR. So I think, if anything, that speaks to the importance of DISSECT in tackling that those unsteady foundations head on. So moving on to my topic, which is Article 18 of the European Convention on Human Rights, and particularly evidence in that context. I'll look to give you a very brief outline of Article 18. I won't try and do an exhaustive or detailed case review some of my peers have done. I will then look at the test, the evidence, the approach to evidence as it presently stands. I'll then highlight, in my view, some present and pardon the pun, which you'll soon come to realize, predominant problems, and some future solutions, in some cases, arguably quick fixes. So moving to Article 18 itself, the provision entitled "The Limitation on the Use of Restrictions on Rights" provides that the restrictions permitted under this convention to said rights and freedoms shall not be applied for any purpose other than those for which they have been prescribed. Very, very quickly, it is parasitic in nature. It's comparable to Article 14 in that regard. It is of critical importance, or is of growing critical importance as a response to the erosion of the rule of law, and prevents or presents particular potential for the courts in sort of fulfilling its role to call out states when those measures are suspected. Again, I don't want to delve into the travaux or the object and purpose or perceived object and purpose too much, just with the focus being on evidence, but it's safe to say that the relevant travaux is suggestive that the provision is intended to provide an alarm bell function. There is also important signs that Article 18 can assist in terms of the implementation of judgments. So pitching all of that, it's clear that it's an incredibly important provision, and it has inherent potential in terms of landscaping the future of the court's role. Notwithstanding this value and its presence within its formulation, the provision was given incredibly or surprisingly limited attention from the Commission and subsequently the court from the 1950s all the way up really to the 21st centuries. The reasons for this delayed engagement, again, will probably take me outside the realms of this conference, but the rise in populist governments and anti-democratic tendencies is a clear factor in the growing attention. Moving on to the court's original approach, and I think this is very important in terms of outlining the change in the approach to evidence under Article 18. Once the court finally did start to engage with the provision, it appeared to assign an incredibly, arguably insurmountable burden on the applicants. The earlier cases, such as Jasinski and Khodorkovsky against Russia, imposed the standard of incontrovertible and direct proof, and hinted that the burden of proof rested on the applicant. In practice, this meant that the applicants effectively had to catch states with their hand in their cookie jar in terms of the states caught red-handed in pursuing an ulterior motive when adopting a restriction on a right. For instance, this is very clearly exemplified in the inaugural violation of Article 18 in the Jasinski case, which concerned the detention of a media tycoon and Putin critic, and assessed whether this detention was pursuing an ulterior motive, specifically coercing this individual to sell his critical media outlet. The court was provided by the applicant a written document signed by him and the Russian state minister, providing that the applicant would sell his media outlet in exchange for his freedom, his release from detention. So this indeed was found by the court to constitute incontrovertible and direct proof, and a violation of Article 18 was found. It is not difficult for us to imagine the scarcity of such evidence in other cases, and this very high evidentiary threshold largely explains the restricted or very limited findings of violations. For example, from approximately 80 judgments which I've surveyed so far, very briefly, as I'm at the preliminary stage of my research, 6 violations were found, which equates to about 7.5%. From 2017 to the date of this conference, 12 judgments were found from 12 violations of Article 18 were found from 24 judgments. That's supercharging it to approximately 50%. So this really can only be explained by the Morabish Phillips Grand Chamber judgment. The importance of this judgment really cannot be overstated. Now, Morabish Phillips concerned the detention of a Georgian politician or opposition politician who was formerly a relevant minister of the Interior and also served tenure as Prime Minister. Now, he was detained for some time by the authorities, and one night it was alleged that he was taken out of his cell and effectively blackmailed by state authorities again. In short, the allegation was he was told he could sell out his political allies and colleagues in exchange for release from detention. Now, Morabish Phillips did really 3 critical things, 2 of them positive in my view, 1 of them negative. The 2 positive things it did was normalize the burden and the standard of proof in the context of Article 18. So contrasting this incontrovertible and direct proof standard to the post-Morabish Phillips standard, the court has provided that it should just adopt its usual approach, that being the beyond reasonable doubt standard. Further, it held that the burden of proof should not really rest solely on the applicant, and instead should rest on neither party, again adopting recourse to its original or its usual approach to the burden of proof. The second second positive crucial thing that the Morabish Phillips judgment did was recognize the value of circumstantial evidence in assessing whether or not a state has pursued an ulterior motive in a certain case. Now, this isn't an exhaustive list of circumstantial evidence, and the list is of what the court is considering in terms of this circumstantial evidence category is growing in Article 18's case law. But it's safe to say that the reports from international observers, non-governmental organizations, particularly the Commissioner for Human Rights, is playing an ever more crucial role. In terms of the post-Morabish Philly, actually one more word on circumstantial evidence. What we're also seeing is this is providing a stepping stone in terms of allowing the court to arguably internalize circumstantial evidence. So having made findings of fact in earlier Article 18 cases, particularly those relating to Azerbaijan, in subsequent Azerbaijani cases, it's making findings of fact based on references to previous Azerbaijani cases which have made their findings of fact based on circumstantial evidence. So it's a snowballing effect, which really is kind of adding to, we've discussed credibility here, but the credibility of circumstantial evidence. And that culminates in that internalization I've discussed. Unfortunately, the internalization doesn't apply to all states, as we'll come on to see. Now, I highlighted that there were three crucial elements to the Morabish Philly judgment, and two of them are positive. One of them, in my view, is negative, and several academics agree with this observation. Now, the negative advancement is the creation of the predominant purpose test. Now, the effect of this test is far more succinctly explained than me by Dr. Tevlakos at Liverpool University. And you'll see that it kind of comes into play as an additional barrier to the court's approach, or the court's assessment, rather. So once it has assessed whether there is a ulterior motive in play, it will question whether there is a plurality of purposes. So if there are different motivations behind a state's action or adoption of a measure. Now, if it is, it will look to assess whether it is the predominant one, and how exactly it determines the predominance is really very ambiguous. The only indication it's provided in Morabish Philly in the judgment itself, in terms of how it determines predominance, is it will give due regard to all circumstances within the case. In assessing the point of predominance, the court will have regard to the nature and degree of reprehensibility of the alleged ulterior purpose. And bear in mind that the convention was designed to maintain and promote the ideals of a democratic society and the rule of law. Now, Florestan has correctly pointed out that one motive's, the purpose's reprehensibility and its predominance may be entirely related or unrelated, I should say, in practice. Now, these criticisms have been echoed by practitioners and quasi-academic practitioners such as Philip Leach, and these are very well merited. Unfortunately, the court has done little to flesh out this criteria in subsequent cases. Instead, it has adopted an even more complex approach of time slicing. Now, when I say time slicing, I mean looking at certain instances or starting the clock at certain points in the chronology of a case file to identify predominance at that stage. And that was very prevalent in both the Navalny Grand Chamber judgment and the Dimitrov Chamber judgment, which was it was a welcomed advancement when the court moved away from that time slicing approach in the Grand Chamber judgment and found an Article 18 violation in the context of the whole chronology of the case file. Now, the reason why I'm a bit skeptical about time slicing is I do have a concern personally, although I'm yet to substantiate this concern, that time slicing risks watering down the effects of Article 18. It just safe to say that there can be concern there if they look at a very narrow instance and say that it was only an ulterior purpose for a small window rather than the entirety of events and behind the original decision. The more theoretical concern regarding the test concerns its money laundering effect, in that if you have a mixed bag of purposes, provided that the predominant, the ulterior purpose, the nefarious purpose is a minority, the test will be legitimized and normalized and really effectively affirmed by the court. In terms of the further criticisms which have followed more broadly from Morabish Phillips, is the ambiguity surrounding the value of circumstantial evidence, notwithstanding a very, very welcomed recognition in Morabish Phillips. Subsequent cases such as Sambuku have called in or cast into question the exact value of circumstantial evidence and how far that goes in establishing or satisfying the new normalized standard of proof. Lastly, inconsistent and incoherent reasoning concerning Article 18 and arguably conflict within its own case law furthers the already very prevalent risk of politicization or arguments of politicization in terms of the court's use of Article 18 to target, quote unquote, certain member states. In terms of future solutions or short-term fixes to these problems, the court has a few. I should say that I've categorized these from the court's perspective and from the applicant's perspective, but I suppose each one could be turned on its head to fit the respective actor. But the abandonment of the predominant purpose test may be one way for the court to move away or clarify and ensure more coherency in its Article 18 case law. This is highly unlikely given the fact that it's doubled down on the predominant purpose test in its two subsequent ECHR Grand Chamber judgments, but shifting to a focus on causality rather than predominance may serve to really give true effect to Article 18's true potential. Another idea is adoption or explicit recognition of the shifting of the burden of proof. Thus far, there's signs that this is implicit, but it's not gone as far as it has done in the Article 14 cases, which were discussed in the first presentation, to explicitly shifting the burden of proof in the context of Article 18. Further option may be the adoption or expansion, I should say, of the time slicing approach, but my concerns regarding that approach have already been outlined. Turning to the applicant's perspective, I think greater utilization of inferences will be crucial in the further development of Article 18, considering its nefarious and covert nature. Inspiration may be drawn here from Rule 44 and tactical pleadings in terms of applicant tactical pleadings, and I'd welcome comments from the practitioners in the Zoom on that point. Another point, another possible solution or short-term fix would be holistic argumentation. And on this point, I'd press on Sambuku, which found a violation of Article 10. And although the Article 18 case related to Article 5 and Article 10, the Article 10 reasoning in that case stopped short of assessing the legitimate aim. So it only assessed whether it was prescribed by law and found that that wasn't the case, and in turn a violation. I think the applicant, and I'm not sure if the applicant did, I wasn't involved in I haven't had an opportunity to interview anybody on that point, but if the applicant had pushed further, or if the court had spent more time in its judgment assessing the legitimate aim concerning Article 10, it may have added more weight to the argumentation pertaining to Article 18, and it would have allowed a more scrutiny in terms of the court's assessment of the Article 18 complaint. Lastly, a more strategic use of Article 18 could be advocated for in terms of when to raise the complaint and only go for cases which present a slam dunk opportunity. And another option may be the effective argumentation of time slicing. I think above all, what is recommended though is a commonsensical approach, and this is a provision that has provoked 5,000 word dissents within the court and continues to deliver divided judgments. Morabish Phillips itself was split 8-7 in the finding of an Article 18 violation. One of the consistent advocates for more attention and a more proactive rather than reactive effective use of Article 18 is judge curious. And I just find this commonsensical approach which he advocates, although it may not fully relieve and address the incoherency and inconsistency arguments and also transparency arguments, if it does walk like a duck and swim like a duck and quacks like a duck, we do call that bird a duck. And I think the same can be said when states do act in flagrant disregard for the rule of law and democratic society. We should call those states out. And I'd welcome your comments on the practical solutions and short-term fixes I've put forward. Thank you very much for the floor.
Thank you very much, Joe. It's really very interesting.